All right, we are now live. Hi, everybody. My name is Emily Brown, and I'm the founder and principal attorney of Elevate Justice U.S. Immigration Law. And this is our inaugural I-9 compliance series where we go live on Wednesdays at 12 p.m. Central, 1 p.m. Eastern. It's our I-9 compliance corner. Elevate Justice U.S. Immigration Law is a private immigration law firm, and we specialize in immigration compliance, including I-9 and E-Verify compliance. Today, as we get started, before we dive in, everything that I'm going to share today is general educational information. It's not legal advice specific to your situation. Immigration enforcement is constantly evolving and changing. For guidance tailored to your business, you need to consult a qualified immigration attorney. So, as you may have heard, ICE has now updated their enforcement guidance when it comes to I-9 inspections. So if your company did an I-9 audit in the last few years and you walked away with a list of technical errors, those errors may no longer be technical errors that you can fix. They now may have been reclassified as substantive errors that can actually cause your company to be at risk for an increase of hundreds of thousands of dollars in fines. A little bit of background. So in 1997, we had the Virtue Memo, and it distinguished between what was a technical and a correctable fine versus what is a substantive fine, or sorry, a technical error and correctable versus a substantive error, which is actually then finable by ICE during an I-9 inspection. ICE followed this guidance for 29 years, and it essentially functioned like a regulation. But on March 16th, 2026, ICE quietly published an updated I-9 inspection fact sheet, and the Virtue Memo is essentially gone. They have reworked essentially what is a technical error and what is a substantive error. So what's exactly changed? The biggest and most notable change is essentially previously, if you had technical errors on your I-9 related to documents that the employee provided to you, if you kept a copy of those documents on file, you were allowed to then go back to your I-9 and write in or correct information because you were relying on copies of the documents presented to you at the time of completion of the I-9. That is no longer the case. Keeping copies of the documents presented to you is no longer a safeguard if you're not completing the I-9 correctly. You're not going to be able to go back and make those changes. And if ICE shows up to audit your company, you could be essentially held liable and assessed fines for those violations now almost immediately. So let's talk a little bit about what actually are those fines now or errors now that are considered substantive that used to be technical. So in section 1, that's the section that the employee will complete. In section 1, if it's missing the USCIS or A number in the box, the attestation box, or if you're missing that document expiration date in the attestation box, that is now a substantive error. So regardless of whether you've saved a copy of the EAD or the I-94 record, if that information is not properly listed in section 1, that's going to be a substantive error. Also, missing the employee's date of birth in section 1 is a substantive error. Section 2, incomplete document info in the different lists. So in each list, I know a lot of employers would just make a copy, put the copy in the file and be like, yeah, we'll fix it. We'll fill it out properly, potentially not until an ICE audit shows up. However, if you're not putting that document information under either list A, B, or C, when the employee is presenting those documents to you, you're now going to be held liable, and that's going to be a substantive error that you could be fined for. Having a copy of those documents no longer protects you. So you have to do it when you're completing the I-9 in real time. And for section 2, that's by the 3rd day of employment. Also, missing the first day of employment for the employee in the certification in section 2, that's also a substantive fine. Also related to section 2, now that since 2023, you are allowed to remotely verify workers if you are enrolled in E-Verify. This is only if you're enrolled in E-Verify. You are now allowed to remotely verify your workers over a video chat. There's a box in section 2 that you're supposed to check if that is what you've done for that employee. And if you're not checking that box, that's a substantive error. You cannot remotely verify your employees if you are not enrolled in E-Verify. So please make sure you understand that distinction. The other thing is electronic signatures on I-9s. So if you're just downloading the most recent PDF of the I-9 from the USCIS website and having your employee fill it out and then typing in the signature thinking that's sufficient, it's not. When you're electronically signing a Form I-9, there are specific I-9 regulations that establishes whether or not that signature is sufficient. If you're using an electronic I-9 software, it is important to be aware that sometimes these softwares or programs have different tiers and membership levels, and not all tiers have the proper I-9 compliance functionalities. So I do recommend checking with your electronic I-9 system and making sure it has the proper I-9 safeguards in place for e-signatures and for storage. Some of the things that you're looking for is that the I-9 electronic software system is completing an audit trail. So anytime someone goes into that I-9 form to make any edits or changes, it's keeping a log of what happened and what those changes are. That's required by the I-9 regulations that your I-9 electronic system does that. So again, if you're using electronic I-9 software, you want to confirm that it's compliant with the I-9 regulations and not giving you a false sense of security and instead giving you electronic signatures that are not compliant, which can then be a substantive error that you are fined for. So the critical point here is essentially that keeping documents of the ID documents is no longer a protection if you have technical errors on the form that you were planning on going back to later. ICE has eliminated that completely on its face, period. So it's not saying don't keep copies of the documents. That's something to consider still as a business process down the line. But when it comes to whether or not you can correct those errors on the form, keeping the document copies no longer protects you. There are still a number of technical errors, and I'm going to drop the link here in the comments to ICE's updated I-9 inspection fact sheet, which lists the technical errors that are still out there. And if you do have technical errors, you will still be given a 10-day window to correct those errors, but there's just not many of them anymore. And then for the substantive violations, if you're audited by ICE, there's no correction window. You could be subject to fines immediately. The companies who are going to be at most risk here are the ones where you have a lot of technical errors that you were just kind of putting on the back burner thinking that you were safe. But now those errors may have converted into substantive errors. And that's a pretty big deal. So currently the fines for I-9, for an I-9 paperwork violation range from $288 to $2,861. So say you're a company with 500 employees, and maybe half of that, even 250 employees, it was a common HR practice to perhaps just take a copy of the documents and fix it later. Or, maybe you're not watching the employees as they're doing Section 1, so they're not properly completing the attestation, writing their A number and writing their expiration, and you never went back to make sure they were doing it properly. So say it's 500 employees, and now half of your workforce have these types of errors. That's 250 employees. At the bottom end of the fine structure right now, $288, that's going to be $72,000 in fines from ICE. That's at the bottom range. If we're looking at the top range of $2,861 per form, that could be over $715,000 that ICE can now assess in fines for errors that used to be technical but are now substantive because you cannot correct them even if you have copies of the documents presented at the time the I-9 was completed. The other thing that's really important to think about is ICE is not going to quietly rewrite this guidance and update a public-facing website for no reason, essentially overturning 29 years of guidance that was common practice. So when ICE is doing this, or when any government agency does this, it really means that they probably intend to use it. So not only was ICE enforcement up in the past couple of years with the current administration, but this is signaling that it might even get even more increased in the amount of ICE audits for I-9s that we are seeing. And there is a disproportionate effect that we're seeing on industry. So I-9 audits are really common potentially in construction, staffing, hospitality, manufacturing. So it's really important now with these changes that you get ahead of it now before a notice of inspection arrives. So what can you do about it? Your going to want to go back to your company and pull your last internal audit report and see if there are, a common theme of technical errors. You might not be able to fix them now, but if you can see what the common error was that might be repeating, you can, look at your current HR practices and I-9 practices and stop it in its tracks, so you're not continuing to complete that error. So you can kind of do a corrective action plan there. If you haven't done an internal audit in more than a year, it's definitely time to do one. Make sure your I-9s are in shape, or so you at least understand where you are and what your risk is. The other thing that you need to do is to stop relying on copies of the documents that the employees are providing to you. You're going to need to retrain your team now to make sure that they are actually verifying the document the information on the documents, and that is properly listed on the I-9s timely. We still need to meet those timelines too. Employee must complete Section 1 by the first day of work for pay. Employee must complete Section 2 by the third business day. Lastly, like I mentioned earlier, you want to audit your electronic I-9 systems and make sure that the plan that you're on is actually complying with the I-9 regulations. And if you're using remote verification as an E-Verify user, you want to make sure that you're not missing that little tiny box in Section 2. If you are doing it, you want to make sure that is checked. So in summary, ICE didn't change the law. They're essentially just changing the enforcement framework. And the employers that are most at risk are the ones that they've done an internal audit, they know they have the technical errors, they put it on the back burner and didn't fix it, and they just stopped there. So now a lot of those errors might have converted to substantive errors. Okay, so I know this was a lot. This is a big change in terms of the I-9 compliance world. If you're not sure where you or your company stands, you can start with our compliance assessment. It's a 60-minute attorney consultation with a written risk report and a prioritized action plan. And that's going to tell you everything that you need to know. If you already know you're going to need ongoing I-9 support, Immigration Suite is our monthly I-9 legal subscription. You get direct attorney access, I-9 review actively during onboarding, E-Verify support, and annual training. And our plans right now are currently starting at $297 a month, so there's no surprise invoices. Immigration Suite members also receive a 15% discount off of our other flat fee legal services, and that includes the compliance assessment, even starting once you sign up for our Immigration Suite waitlist. So our founding member prices for Immigration Suite are ending on April 30th. They're subject to increase after that. But if you're interested in learning more about our monthly support, you can scan the QR code right here. That's going to bring you to our website so you can learn more about Immigration Suite generally. You can sign up for the waitlist there, or you can also sign up for the waitlist here so that you can access it and join and claim your founding member pricing, as well as the 15% discount for the compliance assessment if that's something that you're interested in. So it was a pleasure to update all of you this week. Like I said, I'm going to be doing this every Wednesday now. It's my I-9 Compliance Corner. I hope to see you and that you can join me. I will be posting the topics that are coming. I try to do it as early as I can, but I look forward to seeing you. My name is Emily Brown, and again, I'm the founder and principal attorney of Elevate Justice U.S. Immigration Law. You can always follow me, DM me. I'm happy to answer your I-9 questions in the meantime. So I hope you have a great rest of your week and that you found this helpful. Take care, everybody.